second marriages, legal battles, and your kids getting nothing. Today we're diving into the latest legal drama to come out of the California Court of Appeals. This case is Reich v. Reich, a tale of IRAs, trusts, and yes, second marriages. The big question we're tackling is this: can your IRA bypass your carefully crafted estate plan and go directly to your children, even if you're remarried? Spoiler, it can, but maybe not without a fight. If this piques your interest, and it should, don't forget to like, subscribe, share the video with anyone you know who's on a second marriage, and let's get into it. What happened in Reich v. Reich? This case involves Thomas Reich, who created a revocable living trust back in 2016. In his trust, Thomas specified that upon his death, two testamentary trusts would be created, one for his daughter and another for his granddaughter. He also designated these testamentary trusts as the beneficiary of his IRA, an account valued at about $1.5 million at the time of his death. A testamentary trust is a trust that is created because of someone passing away. In this case, Thomas's trust specified that when he died, there would be two subtrusts or testamentary trusts that would be created from his living trust, and this IRA, off to the side, would send money specifically to these two testamentary trusts. Enter Pamela Reich, Thomas's wife of just 7.5 months at the time of his passing. Pamela claimed that she was an omitted spouse, arguing that the IRA funds should be included in the calculation of her statutory share of Thomas's estate under the California Probate Code. Her logic was that since the IRA proceeds were set to flow into the testamentary trusts, which are created by Thomas's living trust, they must first pass through the living trust itself, making them fair game for her omitted spouse's share. Think about it this way. Country X has a gas pipeline that passes through Country Y to get to Country Z. Country Y is going to charge a fee and maybe skim some gas off the top before it makes its way over to Country Z, since the gas had to pass through Country Y in the first place. Thomas's trust is Country X, the testamentary trust for daughter and granddaughter are Country Z, and Pamela is there in the middle as Country Y. At least the way she sees it. The trial court didn't buy it, and neither did the Court of Appeals. Both ruled that the IRA proceeds bypassed the living trust entirely and went straight to the testamentary trust. As a result, Pamela was left empty-handed, at least as far as it went with the IRA money. But what's an omitted spouse anyway? For those unfamiliar, an omitted spouse is someone who marries a person after that person has already created their estate plan, but they aren't mentioned in it. California law generally assumes this omission was unintentional and allows the surviving spouse to claim a share of the estate. But here's the catch. That share is drawn only from the decedent's estate, which includes assets in probate or a revocable trust that becomes irrevocable upon the decedent's death. Assets like IRAs, which are classified as non-probate assets, typically don't count unless they are specifically funneled through a trust or estate. If the asset in question has a designated beneficiary that is not the living trust, then it's a non-probate asset. If the beneficiary designated is the IRA owner's living trust, then, and only then, those IRA proceeds are part of their trust estate. And this distinction is exactly what St. Pamela's claim. The appellate court's decision rested on 3 key points. First, the IRA proceeds were non-probate assets. IRAs are governed by federal law and are designed to pass directly to designated beneficiaries upon the account holder's death. In this case, the IRA didn't list Thomas's living trust as a beneficiary, it named the testamentary trust directly. This means the funds bypass the living trust entirely. Second, testamentary trusts are separate legal entities. Although the testamentary trusts were created by the living trust, they became distinct entities upon Thomas's death. The court noted that the IRA funds went straight to these testamentary trusts, not through the living trust. Pamela's argument that the funds had to be marshaled through the living trust was rejected as a misunderstanding of how the assets were structured. And third, Thomas's intent was clear. The court emphasized that Thomas's intent to leave the IRA proceeds to his daughter and granddaughter was crystal clear. As the opinion stated, the whole purpose of the probate law is to effectuate the decedent's intent. Allowing Pamela to claim a share of the IRA would have defeated that intent, as in, Thomas wouldn't have wanted that, at least as far as we can tell. But what can we learn from this case? Quite a bit, actually, especially if you're in a blended family or have complex estate planning needs. Number 1, double check your beneficiary designations. Your IRA beneficiary designations override your trust or will. If your intent is for those funds to flow through your estate, you must explicitly name your trust as the beneficiary. Number 2, communicate your estate plan. Thomas's decision to exclude Pamela from his IRA likely reflected his intent, but failing to update his living trust after marriage left room for litigation. Clear communication with your spouse and heirs can prevent disputes just like this one. And number 3, understand the limits of omitted spouse protections. California's omitted spouse statutes are powerful, but they don't apply to non-probate assets, like IRAs, unless those assets pass through the estate or trust. And I do have a video where I discuss omitted spouses and children, so I'll link to that if you want a deeper dive in there. It's a lot more drama. On a side note, let's not forget the unspoken lesson here. Maybe don't get married 7.5 months before you die and not update your estate plan. It's like Thomas thought, I'll just let the courts sort it all out, and then left Pamela and his daughter to duke it out in probate court. Lawyers, not like me, the bad ones, thank people like Thomas for the business, but I'm sure his family could have done without the drama at the end of the day. In the end, the Reich v. Reich ruling highlights the importance of precise planning and regular updates to your estate planning documents. Beneficiary designations, trust structures, and even the laws governing omitted spouse can dramatically impact the outcome of your estate plan. The situations where you must update your estate plan are when you get married, widowed, or divorced, or the birth, death, or adoption of a child. A change in your family means a change for your trust. But what do you think about this case? Should Pamela have gotten a share of the IRA, or did the courts get it right? Let me know in the comments below. Thanks for watching. Don't forget to like, subscribe, and share the video with Dad before he marries his new girlfriend. I'm attorney Andrew Bethel, and I'll see you at our next meeting.